Good afternoon, everyone, especially to our instructor, Tony Cham, and a fellow junior interns classmates. So I will be discussing about the death or absence of a witness. Prior testimony, such as disposition or testimony in earlier proceeding, is admissible if the adverse party had an opportunity to cross-examine. This modifies a fairness and prevents delays when witness unavailable. Meaning na paminaw ng statement sa pikas party, una ang cross-examine. Recalling a witness. This means the court may recall a witness for further examination if justice requires to avoid repetitive questioning. Ang meaning niya kay ang korte mahimong patawag pag-usab sa usa ka saksi o witness sa dugang pagpangutana kung gikinahanglan sa hustisya aron malikayan ang pagbalik-balik sa pangutana sa usa ka witness. Leading questions still prohibited during direct examination, but exceptions clarified. Preliminary matters, witness with difficulty understanding, and hostile witness. Preliminary matters. Non-controversial facts such as witness, name, occupation, or address. This will help exhibit the trial by moving quickly to the court testimony. Witness with difficulty. Mga kuan na siya, mga PWD, mga di kadungog, trouble with communication, or physical disabilities. The hostile witnesses. This occurs if the witness shows unjustified or to testify the interest of adverse to the party who called them. Leading questions to a child witness. The 2019 amendments institutionalized child-sensitive procedures by permitting leading questions, ensuring that children can testify effectively without being overwhelmed by the adversarial nature of court proceedings. So, ang pasabot ani kay ang pangutana na nagpasugot na sa usa ka tubag nga kasagaran gidili sa korte apan gitugutan na karon para sa mga bata aron mas sayon sila makasaysay sa kamatuoran. Misleading question. Strengthened courtroom fairness by expressly banning misleading questions, ensuring that testimony remains truthful and untainted by manipulative questioning. Ang pasabot niya kay ang malig-on nga makiangayon sa usa ka korte pinaagi sa tin-aw na pagdili sa mga nga dili maong tubag sa usa ka pangutana, pagsigurado nga ang testimonya magpabiling tinuod ug dili sa mao na question. Impeachment by contradictory evidence. Impeachment by contradiction or to highlight materiality and relevance, ensuring that contradictions used to attack credibility truly matter to the case. So that impeachment by contradictory evidence, pag himo sa usa ka statement nga usa ka importanteng information na pagsiguro nga wala siya ni sukwahi o namutbot sa usa ka statement nga gigamit niya pag testify og tinuod ba jud nga mahinungdanon sa usa ka kaso or sa case. Impeachment by evidence of conviction of crime. Impeachment by priority inconsistent statements. These 2019 amendments tightened impeachment rules to ensure that credibility attacks are grounded in serious, relevant issues, not trivial conviction or hidden inconsistencies. Ang kasabot niya kay magsiguro nga ang pagkadaot sa kredibilidad sa usa ka tawo mag-base jud sa seryoso ug importanteng rason. Kay kung naay gamay lang na mislead information, iso jud nga ihatag niya o testimony kay base sa iyang relevant information. Impeachment by evidence of conviction of crime. Impeachment by priority inconsistent statements. These 2019 amendments tightened impeachment rules to ensure that credibility attacks are grounded in serious, relevant issues, not trivial conviction or hidden inconsistencies. Ang kasabutan niya kay magsiguro nga ang pagkadaot sa kredibilidad sa usa ka tawo may base jud sa seryoso ug importanteng rason. Kay kung naay gamay lang na mislead information, iso jud nga ihatag niya o testimony kay base sa iyang relevant information.
Good day, everyone. My name is Carlo Cabingatan. I am the third reporter from the Group 3. My first topic is all about the distinction between the marital disqualification rule and the marital privilege communication rule. Marital disqualification rule: a spouse is disqualified from testifying against other. Example: while still married, Anna sees her husband Ben steal phone from a store. In court, Anna is asked to testify, but Anna cannot be forced to testify against Ben. It is because they are still married even though she personally saw the crime. She is disqualified as a witness. Ang pinakarason nga nang gitukod kini nga balaod isn't to protect wrongdoing, but instead giprotektahan lamang niini ang hapsay nga relasyon sa kasado nga managtiayon. In the other hand, marital privilege communication rule: it protects confidential communications between spouses. Example: Ben tells Anna privately at home that he stole a phone yesterday. Even if they are already separated or annulled, Anna cannot reveal what Ben told her because it was confidential communication during the marriage. So, marital privilege communication rule simply says that bisan pag annulled na mo sa imong partner, then ang pagsulti niya sa crime nga iyang nabuhat is that time nga wala pa mo na annulled is still di Japon siya valid sa court because it is covered sa marital privilege communication rule. Attorney-client privilege, Bar 2008. A lawyer cannot be compelled to disclose and cannot testify about any confidential communication made by the client to him, or the legal advice he gave if these were made in the course of their professional relationship. This is protected by attorney-client privilege under 2019 Rules of Evidence. Ang pinaka-purpose ani nga balaod is to encourage client sa pagtug-an toward sa ilang lawyer sa tinuod jud nga nahitabo, para ang lawyer nila makaprotekta sa ilaha sa sakto nga pamaagi. Kay kung ang client dili protektado ani nga balaod, naay dakong posibilidad nga ang ilang mga isulti sa ilang lawyer is naay sagol nga pagpamakak ug dili tinuod nga mga nahitabo. Clergyman penitent privilege. Under the 2019 amendments, a clergyman, priest, minister, or spiritual advisor cannot be compelled to disclose any confidential communication made to him in a professional character as a spiritual advisor. This privilege covers confession or statement made in confidence to a clergyman, spiritual advice or counseling given in response, communication made in the course of religious or spiritual duty. This is protected by a clergyman penitent privilege. It ensures that people can freely confess sins or seek spiritual guidance without fear that their statement will be revealed in a court. It preserves trust between a person and their religious advisor. Physician-patient's privilege, Bar 1998, 2016, and 2018. Under the rules on evidence, a physician cannot be forced to testify or disclose any confidential information learned from a patient if it was given in a course of treatment or consultation. This includes information the patient told the doctor in confidence, finding from a medical examinations or treatment, diagnosis, and medical advice given. This is protected by the physician-patient's privilege. Gi-ensure niini nga motug-an sa tinuod ang kliyente sa way kahadlok na mabulgar sa korte ang personal or mga sensitibo na gipamati or mga sakit sa kliyente. Privilege communication to public officer, This refers to a confidential information given to a public officer in official capacity, which cannot be disclosed if the law or public interest protect its confidentiality. Kani nga balaod na protekta sa mga tao na gusto lamang mo report sa mga krimen sa ilang barangay nga dili mahibal-an ang ilang tinuod nga identity. For example, a citizen reports to a police officer that a drug syndicate is operating in their barangay and gives name of suspects. Later, the defense asks the police officer to reveal the identity of the informant. The officer cannot be forced to disclose the identity if the confidentiality is protected by the law. If revealing it would endanger the informant. Executive privilege, presidential communication privilege. This is a specific type of executive privilege that protects confidential communication directly involving the president in the process of decision making. This privilege ensures that the president can receive frank and honest advice from an advisor without fear of public exposure. It is protected the decision-making process at the highest level of government. Kani nga malaod nagtugot sa isa ka presidente advisor para maprangkahan niya kini para ang presidente makadesisyon og tarong para sa kaayuhan sa atoang nasod. What matters may be disclosed in relation to the right to information on matters of public concerns. Nagpasabot kini nga ang publiko adunay katungod nga makakuha og impormasyon bahin sa mga butang nga makaapekto sa tanan, sama sa mga official records, dokumento ug mga transaksyon sa gobyerno. Apan dili tanan transaksyon sa gobyerno mahimong ipagawas, adunay mga limitasyon nga ginatugutan sa balaod, sama sa mga impormasyon nga makaapekto sa seguridad sa nasod or sa mga privacy sa isa ka tawo. Privileged communication under the rule on electronic evidence. Under the rules on electronic evidence, privileged communication remain protected even if they are stored, sent, or received electronically. Kung ang inyong istorya kay sikreto, pananglitan sa abogado o sa doktor, mapabilin gyapon kini nga sikreto bisan na sa email, chat, or text. Dili kini pwede basta-basta ipagawas o gamiton sa korte kay protektado kini sa balaod.
Impeachment by showing bad reputation. A witness can be impeached by presenting evidence that their general reputation for truth, honesty, or integrity is bad. Word itself in presenting evidence that their general reputation for truth, honesty, or integrity is bad, we must present evidence that their reputation is truth. Kana gani kung unsay na-collect nato na evidence during sa pag-investigation sa crime scene, kana pod atong i-present sa korte. And also, we must protect the integrity of that evidence so that it have the validity used in court. Impeachment by evidence of bad character but by bad reputation. A witness may be impeached by evidence that his or her general reputation for truth, honesty, or integrity is bad, but by evidence is particularly wrongful act. Almost the same rin siya sa impeachment by showing a bad reputation. Pero sa diri nga topic kay naa siya napuno nga bad character. That is particularly wrongful act na kana ganing nangilad ka sa usa ka ebidensya. For example, na collect kag sa duga collect kag drugs din gamay ra. Imo na siyang punan para ang case na ma-file sa korte is mas modako, mas mo deeper iyang violation. Evidence of good character of witness is not admissible until such character has been impeached. It means a party cannot immediately show that their witness is honest. Evidence of good character is only allowed after the witness has been attacked or impeached. This is to prevent unnecessary evidence unless credibility is questioned. For example, after a defense claim witness is untruthful, the prosecutor called a police officer OC in the court. I have worked with the witness in several cases and he know among officer as an honest person. It is admissible because it refers to a general reputation for honesty. No impeachment by evidence of particular wrongful act. A witness may not be impeached by showing that he or she committed specific past wrongful act. It means a witness cannot be discredited by showing specific past bad act like lying in one accident, stealing before, or cheating, which is not discredited kanang mga before nga mga pagpangilad nga mga accident or mga unsa pa ang gibuhat. The law only allows stacking of witness through general reputation for disloyalty, not pointing to individual wrongful act. Example, allowed in the court. The witness has a bad reputation for honesty in the community. This line is a refer to a general rule reputation, so it is admissible in a court. Ang di pwede or not admissible in a court is kaning ang example. The witness lied another case last year. Dili ni siya pwede because it is a specific wrongful act, so it is not admissible in a court. Next is exclusion and separation of witness. On any trial or hearing, the judge may exclude from the court of any witness not at the time under examination, so that he may hear the witness testimony of other witness. The judge may also cause witness to be kept separate and to prevent from conversing with another until all shall have been examined. During a trial, the judge may order that a witness stay outside the courtroom. While others are testifying, they are also to be kept separate from each other and not allowed to talk until all have testified. Ang purpose ato is to prevent nga ang witness from hearing each other sa ilang mga testimony and to avoid copying or changing their own statement. For example, in a robbery cases, there are 3 witnesses. The judge ordered witness B and C to wait outside the courtroom while witness A is testifying. They are also told not to talk each other to maintain that they will not changing information of what the witness in the crime scene and to ensure each witness to give their testimony independently and honesty. Next, when the witness may refer to a memorandum. A witness may be allowed to refresh his or her memory respecting a fact by anything written or recorded by himself or herself, under his or her direction at the time he was the fact occurred or immediate thereafter, or at any other time when the fact was fresh in her mind or memory. He or she knew that the same was correctly written or recorded. That means, if ever during a testimony, if nakalimot siya ang witness mo nag-allow sa court to refresh his or her memory reflecting the fact about sa mga relevant information during that circumstances, and also by anything written or recorded by himself or herself. So bisag unsa nga na-record niya basta relevant siya mo siya gi-allow siya sa court, and also under his or her direction at the time when the fact is occurred. Mo na siya na importante kaayo nga naa siya memorandum or report na matan-aw if ever nakalimot siya, and then immediate thereafter or any other time when the fact was fresh. So during katong fresh pa ang iyang mga idea or personal knowledge about the circumstances, dapat naka-record siya para if ever during a testimonial or bisa dugay na ba na ang hitabo na siya ikatubag as a witness. But in such cases, the writer or record must be produced and may inspected by the adverse party, who may, if he or she choose, cross-examination upon it may be read as evidence. That means, even if na siya mga written record na provide or ma-produce, kinahanglan siya po na i-inspect with the adverse party, and also papilion siya og cross-examination ba upon the read of evidence is para may bawaan if that evidence is na siya validity or wala. A witness may also testify from such a writing or record, though he or she retain no recollection of the particular facts, if he or she is able to swear that a writing record correctly stated the transaction when made. but such evidence must be received with caution. Next is admission, confession, and res inter alios acta rule. First is confession. The declaration of an accused acknowledging his guilt of his offense charge or of any offense necessarily included therein may be given in evidence against him. This means ang usa ka accused person kay iya automatically angkon ang iyang guilt of the crime. Mao ni siya ang confession. Ang ikaduha kay admission. It is the act of declaration or omission of the party which may given in evidence against him or her. It means it is an act or declaration of the party that may be indirectly or responsibility even if it is not a fully an acknowledgement of the guilt. Last is res inter alios acta rule. The right of the party cannot be prejudiced by an act, declaration, or omission of another. It means it is a person's right cannot be affected by the act, statement, or omission of another person. Ang similarities nila kay ang sa confession kay direct admission of guilt ang giangkon niya dayon sa admission kay statement may imply of guilt. Tapos sa actus inter alios acta rule, one person's statement cannot affect another person. Next is effect of admission. The effect of admission is defined by its ability to defend, the need for proof, and its binding nature of the party making it. Diri sa effect of admission kay mas madali nila diri ang judgment it because kay giangkon niya ditso ang iyang mali or ang guilt sa ana nga crime.
So, I'm going to talk about classification of admissions and confessions. But first, let us distinguish them. What is confession and what is admission? So first is the admission. Unsa dining admission? Admission means acknowledgement of fact. Pasabot pag-angkon nga tinuod ang usa ka sitwasyon. While confession means acknowledgement of guilt. Pasabot pag-angkon nga ikaw mismo ang nakasala. So next is judicial admission. An admission made by a party within the same judicial proceeding. It requires no further proof and is conclusive against the party. Meaning, pag-angkon nga gihimo sa party within o nakasulat sa dokumento sa korte na dili na kinahanglan og ebidensya kay nga naman kay giisip na nga tinuod. For example, in a civil case for a car accident, ang akusado nagsulat sa iyang dokumento sa korte na I admit I was the driver of the red car, meaning this is judicial admission. And he cannot deny it. Dili naman niya pwedeng bawion sa trial. Next is extrajudicial admission, an admission made outside of the court or in a different case. It must be proven as evidence like any other fact. Means pag-angkon nga gihimo outside sa korte or in different cases na kinahanglan i-prove ba pinaagi sa ebidensya. For example, after the accident, ang driver niingon sa mga taong nakita, sorry, I wasn't looking at the road. So, kinahanglan pa kaning pamatud-an sa korte pamaagi sa pagtestigo. Next is judicial confession, a direct acknowledgement of guilt made by the accused in open court. This is usually done during an arraignment or pleading guilty. Means pag-angkon sa sala or krimen made by the accused in the open court. Kasagaran ni mahitabo during sa arraignment na modritso ingon na akusado og guilty your honor. So mo na siya ang judicial confession. So last is extrajudicial confession, an acknowledgement of guilt made outside of court, for example to the police. Under the rules, this is not sufficient for conviction unless supported by corpus delicti or proof that a crime actually happened. Hence, pag-angkon sa sala gawa sa korte sama sa pag-angkon ngadto sa pulis. Dili siya basihan para mapriso ang usa ka tawo gawas kung naailang ebidensya nga nagpamatuod nga naay krimen nahitabo. For example, ang suspect gidala sa presinto ug nipirma sa affidavit nga niingon, ako ang nagpatay niya kay naa ko'y pagdumot niya dugay ra. Aron siya mapriso, kinahanglan gihapon ipakita sa korte ang lawas sa biktima ug ang weapon na iyang gigamit. To make it understandable in terms of admission, confession, judicial and extrajudicial, admission means fact or circumstance, meaning partial acknowledgement like I was there in the crime. Confession means guilt or crime, meaning total acknowledgement like I committed a murder. Judicial means inside court, meaning conclusive, no proof needed. And extrajudicial means outside court, meaning needs proof and corroboration. So next is the effect of extrajudicial confession of guilt. Under 1989 rules, Section 3, extrajudicial confession not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. As you noticed, the 1989 rules and 2019 revised rules on evidence for this specific section remains retained, meaning nagpabilin or maura gihapon. Is it because to ensure the protection of the accused against false or coerced confessions? On the general rule, a person cannot be convicted based only a confession they made outside of court, like to the police, media, or private persons. So bisan pa moangkon ang usa ka tawo sa krimen outside sa court, like atubangan sa police, ang law wala nagsalig sa admission alone. Nganuman, is it because bisan ni angko na siya tungod kay gipugos ba siya, githreatened ba siya, or mentally confused? Para mapriso ang akusado, kinahanglan ang prosecutor magpakita og corpus delicti. Buot pasabot, ebidensya nga tinuod gyud nga naay krimen na hitabo, like naay patay nga lawas or naay nawala na butang. Kung walay laing ebidensya gawas sa pag-angkon, dili siya pwede mapriso. So next is the admission of silence. It is an act or declaration made in the presence and within the hearing or observation of a party who does or says nothing when the act or declaration is such as naturally to call for action or comment if not true, and when proper and possible for him or her to do so may be given in evidence against him or her. So means if someone says or does something sa imong atubangan nga dili tinuod or makadaot sa imuha, unya naghilom-hilom ra ka ug wala nimo gidinay, that silence mahimong gabiton na ebidensya against nimo sa korte. For the silence to be deemed an admission, the following are the requisites. First, he heard and understood the statement. So kinahanglan na dunggan jud nimo ang gisulti og nakasabot ka. Second, he was at liberty to make a denial, means naa ka sa sitwasyon where you were free to speak up without fear or immediate harm or being forced to stay quiet. Third, that the statement was about a matter affecting his right or in which he was interested and which naturally calls for a response. The statement must be important enough, like an accusation, that any normal person would naturally say, "That's not true." Fourth, the facts were within his knowledge. Kinahanglan nakaibaw ka sa tinuod na nitabo. You can't be expected mo deny something nga wala kay kalibutan. Fifth, that the fact admitted from silence is material to the issue, means the silence must relate sa main problem or kaso being discussed. Dili kay random nga an important detail. For its important reminder that the silence during a police investigation or custodial investigation is daily admission. Nga naman, this is because of your constitutional right to remain silent. Under RA 7438, if ang police officer accuses you, you have the right to say nothing and that cannot be used to prove you are guilty. For example, kani nga senaryo, si Pasa og Revener naa sa party, kauban ang daghan nilang amiga. Nikalit og tudlo si Revener ni Paza og ni Shagit. Paza, I saw you steal Borja's laptop sa sakyanan pag-udto. Nganong gibuhat man to nimo? Paza hears it clearly pero wala siya mathreatened And kay bawman siya, asa siya pag-udto. Instead of moingon siya, dili na tinuod klasihan ko gahapon. Instead, si pasa ni tan-aw rang banner ug nagpaisag abaga ani padayon og inom sa beer. In this application for future court case about sa laptop, ang mga amiga ni Pasa pwede mo testify na si Pasa stayed silent when he was accused. Kay tungod ang normal o inosente na tao usually musuko ug modinay sa theft accusations. But Pasa's silence can be considered an admission by silence. So next is the res inter alias acta branches, or the full page res inter alias acta alias nec nocet nec prodes, means thanks done between strangers ought not to injure those who are not parties to them. And there are two branches. First branch is that admission by third party under section 27 rule 130. This branch states that a person's rights cannot be affected by what another person said or did. You are only responsible for your own actions. Meaning, dili mahimong maapektuhan ang imong katungod tungod lang sa gisulti o gibuhat sa laing tao. Ikaw ra ang responsable sa imong kagalingon nga lihok. For example, Dudong is accused of snatching a phone in Colon. The lawyer of the victim wants to show the judge nga si Dudong na aresto og snatching 5 years ago. So ang result, ang judge moingon inadmissible because si Dudong snatcher na 5 years ago. Dili pasabot siya'y nangawat karon. He must judge only kung naay ebidensya sa karon na insidente. For its exemption, this is not absolute. It can be bypassed through vicarious admissions where one person speaks for another. Meaning, sometimes, ang balaod treats two people as one because of their legal relationship. In these cases, what one says can be used against the other, such as admission by a co-partner or agent, admission by a conspirator, and admission by previous or those with a shared legal interest na ma-discuss na later on. So next is ang second branch. While ang first branch kay about unsa ang gibuhat sa ubang tao, ang kaning second branch is about unsa ang gibuhat sa past. So second branch is a similar acts as evidence under section 35 rule 130. Evidence that a person did a certain thing at one time is not admissible to prove that he did the same thing at another time. Just because a person stole yesterday doesn't automatically mean he stole today. Meaning, you cannot prove someone committed a crime today para lang mapakita na they committed similar crime na gibuhat sa past. Ang court mo judge based on the current facts, not on bad reputation or past mistakes. For its exemptions, pwede ra gamiton yung past actions if they help explain why o how the current act happened, like plan, intent, or knowledge. Aron mapakita nga gituyo or dili lang aksidente. Identify or motive kung ang binuhatan sa una kay naay unique signature style and system or habit aron mapakita ang imong sistema o modus operandi sa paghimo og usa ka butang. So next is the distinctions between judicial and extrajudicial confessions. So first is the feature. Were made asa man gihimo. For the judicial admission, these are statements you make formally during sa court process, like in your written answer or while testifying on the stand. For the extrajudicial admission, this act the things you said at home, bar, to a friend, or sa laing sitwasyon unrelated sa court case. So next is need for evidence. Kinahanglan ba og ebidensya? Ang judicial admission, dili na kinahanglan pamatud-an kay ang korte mo accepts its facts immediately, while ang extrajudicial admission kinahanglan pa i-presentar og pamatud-an sa korte pinaagi sa testigo og dokumento nga tinuod gyud nga gisulti nimo. Next is the binding effect. Unsa ka bugat? For the judicial admission, you are stuck with what you said. Dili na pwede nimong bawion unless makaprove ka na you made a huge mistake or obvious error or the palpable mistakes. While in the extrajudicial admission, dili pa final, pwede pa nimo pasabton o i-deny sa korte like nag-joke ra kaato katong gisulti sa akong amiga. So next is the formal requirement. For judicial admission, kinahanglan within the timeline of the specific case being heard, while sa extrajudicial admission, pwedeng pinaagi sa text message, a conversation, or even just a nod of the head. So next is the exemptions to the res inter alias acta rule first branch. So this branch usually what other people say cannot hurt you in court. But these exceptions exist because that law assumes that in certain relationships, the two people are essentially acting as one, such as admission by co-partner or agent under Section 30 Rule 130, admission by co-conspirator under Section 31 Rule 130, and admission by previous under Section 32 Rule 130. For its basis, ang rason on this exceptions exists is that the person speaking at the person affected are in the same boat. Kay tungod, they have the same goals and interests. The law believes that the words of one represents the truth of both. So next is the admission by co-partner or agent under Section 30, Rule 130 of the Revised Rules on Evidence, which details when a statement made by a partner or an agent can be used as evidence against the person who hired or partnered with them or the principal. So an agent is in legal contemplation, a mere extension of the personality of the principal. So meaning, sa mata sa balaod, ang representante or agent speaks or acts for the person who hired them. It is as if the employer themselves is the one speaking, they are treated as one legal person. Both contracts of agency and partnership involve fiduciary relationships, meaning ang relasyon sa pagka-agent or partner gibase sa dako nga pagsalig. Because of that, the law holds the principal responsible sa unsay gisulti sa agent. So for the admission of a co-partner or agent to be admissible, the following requisites must concur. First, the partner or agent must be authorized by the party to make a statement concerning the subject. Kinahanglan the person or agent allowed to speak about the specific topic. And the declaration or act of the partner and agent must have been made or done within the scope of his or her authority, meaning kinahanglan related sa agents ang job or duties. Third, the declaration or act of the partner and agent must have been made or done during the existence of the partnership or agency or while the person making the declaration was still a partner or an agent. So the statement was made while they were still working together, not after they resigned. Fourth, the existence of the partnership or agency is proven by evidence other than the declaration or act of the partner or agent, meaning kinahanglan mapamatud-an na they are partners or agent pamaagi sa laing ebidensya like sa kontrata, dili lang kay the statement itself. For example, in this scenario, Mr. Mabini owns a construction company. He hires Engineer Jaime as his project manager to buy materials. Engineer Jaime goes to a hardware store and says, Mr. Mabini knows we still owe you 500,000 for the cement we took last month. We will pay it soon. So, on applying the requisites, first, Engineer Jaime is authorized to handle material purchases. Second, talking about the debt for cement is part of her job as project manager. Third, she said this while she was still the project manager for Mr. Mabini. Fourth, the hardware store presents the employment contract showing Jaime is Mabini's manager. In the result in court, the hardware store can use Engineer Jaime's statement to prove that Mr. Mabini owns the money. Mr. Mabini cannot say, I didn't say that personally, because Jaime is his extension. So next is the admission by co-conspirator, often called partnership in crime rule. So ang conspirator exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Meaning, ang conspiracy nahitabo kung ang duha o mas daghan pa nga tawo nagkasabot ug ni-decide nga mabuhat og usa ka krimen. Once the conspiracy is proven, the act of one is the act of all. Kung mapamatud-an nga gibuhat sa usa, giisip nga gibuhat sa tanan. Kung ang usa namusil, tanan sila giisip nga namusil sa mata sa balaod. So, to be admissible against co-conspirators, the following must concur. First, the declaration or act must have been made or done during the existence of the conspiracy, meaning the statement was made while the conspiracy was happening or not after they got caught. Second, the declaration or act must relate to the conspiracy, meaning the statement must be part of the plan to help the crime succeed. Third, the conspiracy must be shown by evidence other than the declaration or act, independent evidence to prove existence of conspiracy, meaning you cannot prove conspiracy exists only by using the statement itself. You need other proof like CCTV or witness. So next is the rule requiring concurrence of above elements does not apply when the co-accused takes the witness stand and repeats his extrajudicial confession as a witness, meaning the strict rules above are for things said outside of court. If a co-accused actually goes inside the courtroom, sit on the witness stand, and tells the truth under oath, those previous restrictions vanish. So next is the when he testifies as a witness, his statements become judicial and are admissible not only against him but also against his co-accused. Meaning, kung mo testigo na siya sa korte, ang iyang gisulti maisip na nga judicial testimony. Magamit na kini nga lig-on nga ebidensya kaniya ug sa iyang mga kauban. For example, in this scenario, A, B, and C plan to rob a pawn shop. Samtang nagbiyahe sila, niingon si A ni B, siguro ang nga magapos nimo ang guard. Naggamit ni kang C kay gihimo man ni samtang nagpadayon ang plano. Sa pag-abot sa korte, nitingog gyud si A sa atubangan sa judge. Kaming tulo ang nangawat. Kanang sultia magamit gyud na ebidensya aron mapriso silang tulo.
Admission by preface, where one derives title to property from another, the latter's act, declaration, or omission, in relation to the property, as evidence against the former if done while the latter was holding the title. So what is privity di? It means that there is a mutual or successive relationship to the same rights of property. Example, here's, ikaw ang tagapagmana sa mansion or property sa imong parents. Second is buyers. Nakapalit ka og property or yuta, and the last one is donation. The rule is that kung ikaw ang tagapagmana or nakapalit og yuta, unya ang previous owner na ay giangkon while siya pa ang tag-iya, kana nga pag-angkon pwede na siyang gamiton against you in the court. Requisites for admissibility, first is title transfer. Kinahanglan nakuha nimo ang title or right sa property from that specific person. Second is the relation to property. The statement must be about the property itself, like for example, sa boundaries, defects, or ownership limit. Last one is the timing of admission. This is the most important part. The admission must have been made while the predecessor still held the title. Kung nabaligya na, unya diha pa siya nagsturya sa mga ownership limits, boundaries, or defects, dili na magamit against sa nakapalit. If they made the statement after they already sold it to you, it doesn't count because it only sticks to the property if they said it while they were the legal owners. Example, si Miss Tabada na ay yuta. Samtang iyaha pa ang yuta, nagsuwat siya og letter sa iyang silingan nga si Apple, ana siya. Disubra biya kog 2 ka metro sa imong boundary pre. Years passed by, gibaligya ni Miss Tabada ang iyang yuta ni Jaime. Karon si Jaime nang tag-iya. Ya ug mag-away si Apple ug si Jaime sa court about sa boundary sa property, pwedeng gamito ni Apple ang letter ni Miss Tabada against ni Jaime. Bisag dili si Jaime ang nagsuwat, privy man siya ni Miss Tabada maong si Jaime is affected sa admission ni Miss Tabada. Let's think of it this way. You don't just inherit the land. You also inherit the legal baggage that comes with it. If the previous owner admitted a defect in their title while they still owned it, that admission follows the property to you. You cannot enjoy the rights of the predecessor and at the same time reject their admissions. Alright, guys, let's dive into the offer of compromise. The rules are very specific about when saying sorry or offering money can be used against you in the court. A compromise is basically an agreement to settle a dispute to avoid a trial. But the big question is, if I offer to pay you, does that mean I'm admitting I'm guilty or liable? The answer depends on whether the case is civil or criminal. Offer of compromise in civil cases. In civil cases, an offer of compromise is not an admission of liability. The rule here is that you can offer to settle or pay a certain amount to make the lawsuit go away, and the other side cannot use that offer as evidence to prove you that you owe them money. Offer of compromise in criminal cases. In criminal cases, the rule is the exact opposite. The rule here is an offer of compromise by the accused is generally considered an implied admission of guilt. Because if you didn't do it, why are you offering to pay the victim to drop the charges? In the eyes of the law, kung limpyo kag konsensya, you don't try to buy your way out of a crime. Uy. Exceptions. First, quasi-offenses or criminal negligence, like a car accident, reckless imprudence. Offering to pay for the victim's hospital bills isn't an admission of guilt because these are unintentional. Second is allowed by law, cases that the law expressly allows to be compromised, like certain tax violations or minor offenses. Offer to pay or the payment of medical, hospital, or other expenses. Evidence of offering to pay or paying medical, hospital, or other expenses occasioned by an injury is not admissible to prove liability for the injury. Example, if you hit someone with your car and immediately offer to pay their hospital bills, the law views this as an act of charity or good Samaritan behavior rather than an admission of fault. That's why it is called the Good Samaritan rule. A plea of guilty later withdrawn or an unaccepted offer of a plea of guilty to a lesser offense. It is not admissible in evidence against the accused who made the plea or offer. Neither is any statement made in the course of plea bargaining with the prosecution, which does not result in a plea of guilty or which results in a plea of guilty later withdrawn, admissible. Ari sa ta sa plea of guilty later withdrawn. A plea of guilty later withdrawn is not admissible in evidence against the accused who made the plea or offer. During an arraignment, a defendant might say guilty. However, for various legal reasons siguro wala siya fully nakasabot sa consequences or naay procedural error. The judge allows them to withdraw that plea and change it to not guilty. Once the court grants the withdrawal, the law performs a legal reset. It treats na as non-existent, as if it vanished from the record. This protects the presumption of innocence. This is vital because if the prosecution could tell the jury or judge he already admitted it once, the right to a fair trial and the presumption of innocence would be destroyed. An unaccepted plea of guilty to a lesser offense is not admissible in evidence against the accused who made the plea or offer. This usually happens during plea bargaining. The accused offers to plead guilty to a lower crime to get a lighter sentence. Like, plead guilty na lang ko, Steph, Your Honor. Uy, ayaw lang ng robbery. If the prosecutor or the offended party says, di ko uy, o ididili, the trial continues for the original sentence. The law protects this failed offer because it wants to encourage settlements. If an accused knew that their offer to plead guilty to a lesser crime could be used as an admission if the deal fell through, why defense lawyer na allow ang ilang client nga makig-negotiate because it protects the strategy of the defense. Statements made during plea negotiations. Any statement made by the accused or their counsel during plea bargaining is also inadmissible if the plea doesn't go through. What happens in the bargaining table stays in the bargaining table. Subsequent remedial measures. When, after an event, measures are taken which, if taken previously, would have made the event less likely to occur. Evidence of the subsequent measures is not admissible to prove negligence or culpable conduct in connection with the event. Means that if someone fixes a dangerous situation after an accident happens, the act of fixing it cannot be used in court as proof that they were negligent in the first place. Imagine you trip on a loose wooden plank at a restaurant and break your arm. The next day, the restaurant owner replaces the entire staircase with brand new, non-slip material. Under this rule, you cannot stand up in court and say, "See, they replaced the stairs right after I fell," which prove the old stairs were dangerous and they knew they were negligent. Nganong ga-exist maning nga rule? The law has a very practical reason for this, for public safety. If the law allowed repairs to be used as evidence of guilt, basig ang tag-iya magunahuna na noon nga kung tarungon ko ni karon katong nabulasot gahapon, gamiton pa noon ni against nako in the court. Awon niya na lang oy. The government wants people to fix hazards immediately to prevent the next person from getting hurt. This rule encourages people to prioritize safety over legal strategy. Exceptions. While you can't use the repair to prove negligence, the rules allow this evidence for other specific purposes, such as proving ownership or control. If the defendant claims, "I didn't fix it because it's not my building," you can show they fixed it to prove they actually control the property. Second is feasibility of precaution. If they claim it was impossible to make the stairs safer, you can show they fixed it to prove that a safer version was actually possible. Similar acts as evidence. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he or she did or did not do the same or similar thing at another time, but it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom or usage, and the like. Mao ni siya ang res inter alios acta rule, means a thing done between others does not harm or benefit others. General rule: evidence that a person did something in the past is not proof that he did the same thing now. Dili ingon kay nangawat si A og bike 3 years ago, maingon dayog, "Your Honor, nangawat man gani na siya sa una o idi siya joy nangawat sa kong laptop ron." Dili na pwede. Under this rule, that is inadmissible. Nganong gidili man? Tungod kay gusto sa korte nga ang ebidensya mag-focus sa karon nga panghitabo. Dili na to gusto nga ma-prejudice ang judge tungod lang kay naay record ang tao sa una. Just because you were bad or careless before doesn't automatically mean you are guilty of the specific act being questioned today. We judge the person based on the facts of current case, not their history. However, the law allows to bring up previous acts if you are trying to prove something specific other than bad character. Mao siyang when evidence of similar acts or previous conduct is admissible. Magamit tag acronym nga SIMIC, which means System, Intent, Motive, Identity, and Confirmation. So sa system or habit, to show he has a specific style or pattern. Sa intent, to show he didn't do it by accident. Motive, to show the reason behind the act. Identity, to prove it was him because the signature of the crime is the same. Confirmation or knowledge, to show he knew what he was doing. Mao na ang exceptions. Kung naay signature style ang ilang the way sila mangawat nga sila ra ang nagbuhat, diha na nimo pwedeng gamiton ng ilang past acts para mapamatud-an ang ilang identity. Ang perfect example ani is katong example ni ma'am about sa grupo ni Coco Martin sa Batang Quiapo, katong vendettas, katong the way sila mapatay is magbilin jud sila og kanang ilhanan ba nga sila ang nagbuhat ani.